As far as anyone can tell, 11-year-old Lucretia Murray was the youngest person ever charged with capital murder in Texas. A savage killer, prosecutors say. But enough people, including Amnesty International, have enough doubts about her guilt that they've made Lucretia a poster child for juvenile injustice. Before all this, Lucretia Murray was a more or less typical sixth grader who enjoyed basketball and church. She was a mediocre student who regularly complained about homework. And then one day she went to prison for up to 25 years. The Austin, Texas police say that she brutally beat and killed 2-year-old Jayla Belton, who'd been dropped off at a daycare center Lucretia's grandparents ran in their home. Lucretia Murray, who's now 14 years old, was twice convicted of killing Jayla. Although a judge threw out the first conviction, the second jury quickly found her guilty again, and she's spending her third year in custody with the prospect of another 22 years behind bars. You want to be a lawyer, I understand. Why?
So I can help people staying at places like this.
What did you think of the trial? 2 trials.
I didn't like them.
Why?
'Cause I'm here. They didn't work right.
Did you kill Jayla Belton?
No, I did.
And Barbara Taft, a former legal secretary, believes her.
Nobody did their job in this case. The police didn't do their job in investigating this case. The medical examiner didn't do his job in a proper autopsy. A prosecutor takes an oath to seek the truth, not to prosecute the person in the chair, but to seek the truth. Nobody did that in this case. Nobody.
Barbara Taft was so disillusioned by Lucretia's prosecution that she quit her job at a prestigious law firm in Austin. Now she leads monthly marches to protest Lucretia's conviction, but the prosecutors pay her little heed. Attorneys Rosemary Lemberg and Gary Cobb work for the Travis County District Attorney. 2 of you sitting there right now, you are satisfied she committed the crime and is serving the time?
Yes, sir, but
Beyond the shadow of a doubt.
beyond a reasonable doubt. But what we believe really isn't important. What's important is that 2 juries, 24 individuals, have been convinced of her guilt.
At 6 p.m. on a spring day back in 1996, Lucretia Murray and her grandfather, R.L. Murray, showed up at Brackenridge Hospital with Jayla Belton's lifeless body. Her body showed more than 30 bruises, 4 broken ribs, and a severely damaged liver. She'd been dropped off at the daycare center earlier that morning by her mother's live-in boyfriend. And what led prosecutors to name Lucretia as their prime suspect was the fact she was the last one alone with Jayla.
The key thing is, when did the fatal injury occur? And there's no doubt that that took place just minutes before Lucretia brought her out for her to be taken to the hospital.
The reason you say that is because a child could not survive more than 15 minutes, according to doctors with a split liver.
According to everyone, no child, no adult could survive for that length of time.
But Lucretia's defenders cite evidence that Jayla was already injured and hurting when she was dropped off that morning by the mother's boyfriend, and that once there, she refused to eat, slept, and that there was blood in her vomit.
She was constantly holding her side.
5 days after Jayla died, 11-year-old Lucretia was charged with capital murder. Had she been an adult, she could have gotten the death penalty.
Lucretia Murray was Travis County's very own, very first child killer, and they could taste it.
After Jayla's death, Lucretia had been taken from her family and detained in a children's home where she was questioned at length by police without an attorney or a family member present.
I believe there were 2 police detectives that did the primary questioning.
Judge John Dietz presided over both of Lucretia's trials. She was taken by police from her home, taken to a facility, stayed there, I believe, for 4 days.
4 or 5 days, yes, sir.
She doesn't have an attorney and no member of the family?
That's correct. And your question obviously is, well, isn't there something in Texas law that says that she must be provided an attorney under those circumstances? And the answer is no, there's not.
You have lots of friends in the legal profession, no doubt. They have children. They turn 11 years old. Can you imagine that any one of them would want that child to be interrogated without a parent there? without an attorney there?
Well, of course not, Mike. I am a judge. I'm not a policymaker. It's really up to the legislature to provide that right to the citizens, to the children of Texas.
Barbara Taft has read the transcript of the police interrogation.
No, she said 39 times. Do you hear me? 39 times in the course of 3 hours. I don't know what happened.
Finally, though, after 4 days away from home, Lucretia weakened. Attorney Keith Hampton, who's now handling his young client's appeal, says that she was pressured, prompted by a police detective into signing a statement admitting that she accidentally dropped baby Jayla after she found her shaking and whimpering, and that she kicked Jayla as she was picking her up as she rushed to bring the baby to her grandfather. Attorney Hampton has also read the transcript of the police interrogation.
He tells her in this speech that we won't have to be bothering your family and your grandpa. The signal is, go along with this, and you can save your family from detectives like me.
They needed a confession. They had no physical evidence. They had no forensic evidence. They had no witnesses. They had nothing. Therefore, they were desperate to get a confession.
Lucretia Murray didn't get a lawyer until after she was charged with murder, and that lawyer assigned to her by the state of Texas had never tried a murder case before a jury. And he was given so little money to work with that he never hired a medical expert. How important is medical testimony in a case like this?
Extremely.
Very important. And it helped pinpoint Lucretia.
Absolutely.
How could her first attorney fail to hire even one medical expert to challenge the state's theory of the case?
I really believe that that was more my fault than his, in that I had limited the amount of resources. I mean, at the time, we did not realize the amount of controversy this was
Going to cause.
going to garner.
At trial, Lucretia's lawyer called no witnesses, and the jury, told of her confession, convicted her of criminally negligent homicide. But afterwards, Judge Dietz felt that justice had not been done, so he ordered a new trial. And this time, with more money, Lucretia's new legal team hired Dr. Linda Norton, a forensic pathologist and an expert in child abuse.
This case has bothered me more than any other case in my entire career.
The prosecutors say that all of Jayla's bruises were recent. Therefore, only Lucretia could have done the deed.
I would call that total, absolute nonsense.
Dr. Norton believes that Jayla was beaten before she was dropped off at the Murrays that morning. She showed me pictures of Jayla taken at the autopsy.
It's clear that this is a chronically battered and abused child, a neglected child. You have evidence that this child's forehead has been damaged before. You've got scars all over the forehead. So the notion that you have an attack that has occurred in a 10 to 15 minute period and has produced all of this injury is far-fetched at best.
Until this case, Dr. Norton had always testified for the prosecution in Travis County. Do you believe that Lucretia Murray killed Jayla Belton?
Absolutely not. I'd let her babysit for my own grandchild.
But the prosecutors remained unmoved. And unlike the first trial, they claimed in the second trial to have produced the murder weapon, this pair of tennis shoes they say Lucretia was wearing as she stomped baby Jayla to death.
The injuries resulting in the liver being torn apart were caused by left bruises that matched the print of the shoes that were worn by Lucretia Murray on that day.
Matched the print.
Matched the print.
To support this theory of a matching print, they relied on their own star pathologist, Dr. Vincent DeMeo, who told the jury that the shoe tread and two parallel lines on Jayla's body were, quote, a perfect match.
I talked to the jury after the verdict, and they were dazzled by Dr. DeMaio's repeated insistence that there was a match between that child's body and the shoes and the photographs of shoes that he was given.
Powerful testimony. But Dr. DeMeo now says a perfect match is not exactly what he meant.
You cannot say 100% that they're from the tennis shoe.
From the trial transcript, page 42, question, is the match between these two lines a perfect match with the tread on this shoe? Answer, yes, in my opinion, it is.
That's true. But then...
A perfect match.
Right. But that's just two lines. But then I'm asked the question, can you say, can this mark be due to something else? And I say, yes.
No one has ever looked at two parallel lines on anyone's body and thought tennis shoe.
And yet Dr. DeMeo called it a perfect match.
He called it a...
And he's a man that you respect.
And I do. In fact, he's an excellent forensic pathologist.
Why would he do that?
I don't know.
So what did Dr. DeMeo really mean by the word match? After the trial, in a letter the jury never saw, he told Lucretia's lawyers that match did not necessarily mean a match like a fingerprint, which would point to a single suspect. Instead, he used this analogy, that if a convenience store were robbed by two white males, any two white males would match the suspects. Well, according to that analogy, that limits the suspects in the country to about 100 million people.
Well, he did not testify about that analogy at trial, nor was he asked about that.
Turns out the prosecution's own crime lab couldn't find any match at all, a fact they put in writing, but the jury never heard that because Lucretia's lawyers never told them. Keith Hampton, who was part of Lucretia's legal team, but not the lead trial attorney, wishes they had.
Clearly, that jury should have been told what this expert meant by match wasn't really what anybody else's definition of a match really is.
Tell me this candidly, if you will. Did the lawyers, the defense attorneys, let their client down, in your estimation?
I wish we had done some things that we didn't do.
This thing about the tennis shoe and everything, it's an interesting appeal thing for the attorneys. But the most important thing about this case is, when did the injury occur? If the injury occurred prior to getting there, then the young lady is innocent. And what I'm saying is that that's not what happened.
But Dr. Norton, who spent more than 100 hours examining the evidence, says that is exactly what happened. She says Jayla's liver was first injured before she was dropped off at the Murrays, and then further damaged by medical personnel trying to revive her with CPR at the hospital.
Pushing hard on this chest over 1,000 times. So what you're seeing at autopsy does not represent the original injury.
But the jury did not believe Dr. Norton, and they convicted Lucretia Murray for a second time. What was her reaction?
She did not understand.
She did not?
She just did not.
She didn't know what it meant?
That's right. And I said, it means they think you did it.
Today, this juvenile detention center, this jail just outside of Austin, is home for Lucretia Murray. She's just spent her third Christmas away from her family.
And you know, the remarkable thing about her is that Lucretia doesn't blame anybody. She's not angry at anybody.
What?
She's not. She's not. She believes they made this terrible, terrible mistake. And that one day they're going to wake up and realize they made this mistake and they're going to let her go home.
On Friday, Amnesty International, in response to Lucretia's case and another one like it, asked the Justice Department to review just how police interrogate children in all 50 states. Meanwhile, Lucretia's appeal, which calls into question both the interrogation and the perfect match of the shoe print, is still before the Third Court of Appeals in Austin. A ruling is expected soon.